Yeah, what up? I hope you are doing well. It's Chris down here in Washington, D.C. Ah, lovely week. Also, shout out Morehouse lacrosse team. All right, so today, in preparation for a discussion I'll be leading on Thursday, we're going to talk about the history of restrictive covenants that are based on race, specifically in rural areas of America, of the United States of America. All right, and so keep in mind that this discussion is open to further research. And anything I present in this discussion about restrictive covenants in rural areas, contemporary segregation, and the repercussions, you should further research. Like, don't believe me. Don't think that just because I'm saying it is true. Just possibly use what I'm saying as breadcrumbs to then follow, explore, or investigate. All right, so I'm going to give you a little bit of history of racially restrictive covenants, their influence on contemporary expressions of segregation, and in general, how different entities can work to rectify the situation or to find some form of restorative justice, right? And so I'm going to ask you all a question before we get into the actual subject matter of this. It's, where do white people come from? And I know it seems like a crazy question. I ask that, and most of the time people are like, well, what do you mean? Like the term white folks, like where did that emerge? Do you mean like phenotypically, like the group of European descendants that we categorize as white folks? Like, what does that mean? And so however you define it, if I say, where do white people come from? And you say, well, the term white people, that gets into a history of the self-identification of white folks in unity against the non-white folks around the world. So one example would be in Australia, where you have a group of people from different areas in Europe colonizing Australia, and they realize there are more Aboriginals, and the Aboriginals, if they unify, will be able to stop the encroachment of the Europeans. So at a certain point, they create the Black Laws, and in creating the Black Laws, they also create an identity of being white. Prior to that, they may have been Protestants, or they may have been Catholics, or they may have been Polish, or they may have been Irish, or they may have been a nationality or a religious identity. Who knows? Maybe they were laborers, or maybe they were ranchers. And these are the ways they identified. But at a certain point, groups of people purposely said, we are going to identify as white in order to be in solidarity against all these non-white folks that are around the world that we're attempting to colonize. So that's one idea of like where white people come from in terms of terminology, in terms of nomenclature of why do we use colors to describe people? Like, it's one thing to objectify a person. It's another thing to just name a group of people a color. A color is not even an object. And so how do we understand humanity when we do that? Okay, so let's say we move outside of just the name and we get into the idea of where do white people actually come from phenotypically and genotypically. There's one human race. Like, it's not like dogs where they're different species or breeds of dogs. Like, it's just one human race. So why do we have these understandings of, well, people from this continent are labeled one thing over another? So genetically, people of different blood types are less similar than people of different races. So on a genetic basis, white folks and black folks are relatively similar. Asian folks and black folks and white folks were all similar genetically when you think about humanity. But clearly, phenotypically, we don't express the same way. How? And a lot of folks will say, well, when humans traveled out of Africa and went north and had less access to sunlight and vitamin D, the melanin decreased. Depending on the diet, the melanin decreased. Depending on the weather, the hair changed. And there are all these reasons people have come up with that you end up with people darker than me in certain parts of the world and people lighter than, when you think of Nicole Kidman. The problem is Inuits went north and didn't lose their pigmentation. They have straight hair and are pigmented. People in India, dark skin, but they have straight hair. It gets very confusing when you try to understand, well, where do white people come from? And you realize no one understands any of what they're talking about when it comes to human evolution and when it comes to evolutionary biology. And so that there is no missing link. There's no step in the proto-primate or the predecessor of all of us as humans and the humanoids that went from Homo erectus to Homo habilis to Java man to modern Homo sapiens sapiens. There's no missing link. It went from this to that to Neanderthal to us. It turns out that there were multiple different types of primates running around, and it looks like humans survived. That's one modality of thought. But this notion of where did white people come from? We don't even know where humans came from, how humans actually developed. So we don't know where white people come from. But think about how much of our lives are spent trying to discuss race when it's a fake idea. It's a human construction. It's a social construct. Like, there is no such thing as race in the way we understand it. So when I ask, where do white people come from? It's to remind us that the conversation in general is faulty, that the nomenclature and the language that we have to discuss human identity, if it's based on race or ethnicity or any of those things, is going to be faulty because of the colonial impact, and that it's not real. But much like certain elements of religion or God, once enough people believe something is real, it gets put into action in a real material way. So now that we have an understanding of, there are people that consider themselves white, there are people that called other non-white people savages and animals and did not allow them to be seen as human legally. Like if you think about the United States, the Constitution, people of African descent are to be counted as 3/5 of a person for taxation purposes. Otherwise, they're considered property. So in our founding documents in America, the white folks decided the Africans are property, not humans. So we have to keep that in mind. Even though race is fake, in our Constitution, which is very real when you deal with the police or law enforcement or what have you, you see how it's real. So when we talk about issues of social justice, we have to remember how difficult the conversation is going to be because of how fake the terms are and how embedded they are in social history that has been wildly imbalanced. Okay, so let's talk about like why there's so few black people that own land in rural areas and how restrictive covenants tie into that. Because a lot of us think of restrictive covenants, which are where they're elements of your contract or deed that prevent you from selling your property to a person of a certain background, in this case, racial background. So there are literally pieces of property where on the deed it says this property can never be sold to a Negro. And that was in place in the United States. So we're going to talk a little bit about that. Normally, it's seen as something that happened in urban areas and tied into redlining and city situations. But I found that it also occurred out in rural areas. But let's get in just the history of land ownership in the United States in the first place. So the Homestead Act of 1862 was a law that gave away 270 million acres of public land to private citizens in the United States. This act was signed into law by Abraham Lincoln during the Civil War. Okay, now in 1862, were black folks freed? Had the Emancipation Proclamation taken place yet? No. So in 1862, when a whole lot of folks are allowed to go grab 270 million acres of public land, were black people able to access that? I think you should do some research. Then when you look at the Civil Rights Act of 1866, you're like, wait, there was a Civil Rights Act of 1866? Yeah, it defined citizenship and affirmed that all citizens, including formerly enslaved people, had a right to make contracts, own property, and receive equal protection. However, enforcement was weak. So wait, you're saying prior to 1866, legally, black folks didn't have a right to make contracts? Yes, there were certain scenarios where because black folks were considered property, how can property make a contract? That would be literally like your dog making an agreement with your cat. The law won't recognize that. So if you think about land ownership prior to 1866, what would happen if you were a black person and owned land? Is it possible that you would have issues proving you were the owner? Is it possible that even if you had a contract, a person would say that contract is null and void because you as a person of African descent can't engage in contracts with white folks? So you got to remember then, prior to 1866, people landed in America supposedly as early as 1620. If you believe what I believe, people came earlier than that. They just weren't Europeans. So the Europeans got here in 1620 or around there, the Plymouth Rock. So from 1620 to 1866, black people could be limited in their contractual agreement. So how could they properly own land? So keep that in mind, all right? So then you think about the Southern Black Codes from 1865 to 1866, where they were enacted in southern states to restrict black Americans' freedoms, including property ownership, labor, and mobility, limiting economic and land ownership opportunities, right? That happens following the Civil War. You have all these free black folks, so people in the South are like, whoa, 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 y'all aren't allowed to go anywhere. You're not allowed to gather. You're not allowed to work around here. You're not allowed to buy any property. Figure it out. So then 1865 to 1872, you have the Freedmen's Bureau Act, which was established to help formerly enslaved people transition to freedom, assisting with property claims and education. Limited funding led to its eventual dismantling. So you notice in a bunch of these early acts, you'll have something put into place legally, but it's not funded, it's not supported, it's not enforced. Does that happen now? With the USDA, there have been programs that are supposed to award either loans or insurance claims to farmers that have had areas flooded, but somehow the black farmers didn't get theirs. And when the black farmers sued and won, the government didn't pay them the money. And when they had to sue again to get the money that they were supposed to get from the first suit, they won again and still didn't get the money. So follow that train of thought as we continue through this. So in 1865, we have the Special Field Order number 15, which set aside 400,000 acres of land in the South for black families and 40-acre plots known as 40 acres and a mule. This order was rescinded later in 1865 by President Andrew Johnson. Now, peep this. Homesteading Act opens up 270 million acres of public land to private citizens of the U.S. and does not include black people. Special Field Order only sets aside 400,000 acres in the South, not the North, not out West, in the South for black families and 40-acre plots, and was rescinded. It was passed in 1865 and rescinded in the same year. And reparations were given to slaveholders. Literally, following the Civil War, there were white folks who claimed reparations because their property was destroyed or stolen during the Civil War. Some of that property were the slaves that were freed or escaped, or when the property burned down, were no longer being held captive. All right, so that's wild. So now we'll move on to the Southern Homesteading Act of 1866, reserved public land in 5 southern states for free black people and loyal whites. However, poor soil quality and local resistance made it difficult for black families to retain land. So how were black people supposed to own land? Prior to 1866, we couldn't really hold contracts, and depending on where you were in the country, could be captured and put into servitude. After 1866, they come up with the 40 acres and a mule and say, no, we're actually not going to do that. And then you have things like the Southern Homestead Act where it's like, no, we have space for black people, but you're not going to be able to grow anything there. And we knew that, and that's why we gave it to you. As well as we're going to put up burning crosses, threaten you, and torture your kids when they're at school. But hold on to the land, put yourself up by the bootstraps. Interesting concepts, all right? So then you have the Civil Rights Act of 1875. Again, we have Civil Rights Act going all the way back to the 1800s. Of 1875, guaranteed equal access to public accommodations and services, including property rights. So wait, you're saying prior to 1875 that it was possible to limit public accommodations, not just private, but public accommodations, and limit who could own property? Okay, so we finally, in 1875, get our Civil Rights Act passed, which guarantees equal access to public accommodations and services, including property rights. But portions were struck down by the Supreme Court in 1883, weakening its enforcement. So you're telling me that the Supreme Court used to enforce policy that established segregation, that limited what black people could do, that limited equal rights? Yes, some of the Civil Rights Act removed rights from people. It guaranteed racism. All right, 1875. So then you look, Jim Crow laws, which are established late 19th, early 20th century, enacted at state and local levels. These laws institutionalized racial segregation, limiting black people's ability to acquire and retain land and impacting economic and social mobility, right? Economic and social mobility. You have Jim Crow laws, which limit where you can go, where you can live, who you can be around. There were laws against interracial dating and sex. All right, so keep in mind, up until, I believe, the 60s or 70s, it was illegal for black people and white people to be cohabitating. So there are literally legal cases where if a black man and a black woman fell in love, people could go to jail. If a white man and a black woman fell in love, people could go to jail. That happened all the way up until the 60s and 70s. You have to understand how deep these Jim Crow laws are. So if you're not allowed to date each other, you're not allowed to live in neighborhoods with each other, you're not allowed to work together, you're not allowed to spend time in recreational areas together. This is imposed by local governments, state governments, and at different times federal government. What do you expect to happen? So when you look up in 2025 and you say, why is there such a culture war? Maybe because in our formation, we legally embedded partitioning, and so that people have not been dating each other, working together, partying together, raising kids together, educating each other together, except for the past 50 years. In a 400 to 500 year time period of American history, if you start at the 1600s, it's been only in the past 50 to 60 years where the different races were allowed to do things together. All right? It was prevented prior to that. Keep in mind, so we talking about land, but just understand the total worldview here. How do you have money to buy land if you can't work in jobs that make you the most amount of money? How can you get a loan to buy a house if the banks have already decided we don't grant loans to this group of racially segregated people? Or you can only go to a specific number of banks that cannot access funding at a higher level or get the insurance at a higher level. We'll keep going. We're talking about land here, though. Then you have the New Deal policies in the 1930s. Some programs offered benefits to landowners, but black farmers, often tenant farmers rather than landowners, were largely excluded, leading it to a decline of black farmland, which lets you tap in. A question I would ask is, how do you have more black farm owners in 1890 than now, numerically, not per capita, not percentage-wise, but literally numerically. Just based on population growth, there should be more black farm owners now than at any other time in U.S. history. But there aren't. Black farmers used to make up 13 to 14% of black farms in 1890. We make up less than 1% now. So when you look at some of the policies that granted expansion, some of the highway programs, some of the rural expansion programs, they not only benefited white folks to a large extent, there are also policies embedded that were detrimental to people of African descent. Even something like the GI Bill in 1944 offered low-interest home loans and educational benefits to veterans, but discriminatory practices limited access for black veterans, widening the wealth gap between white and black families. So what you have to look at in land, it's not just the Homestead Act, which gives land to white folks, but then it's the stripping of land that were owned by black folks. It's not just the GI Bill to where it allows for expansion, but that black people weren't given access to it. So that while this expansion occurs, there's either a stifling of growth or atrophy. And so when you look up by 2025, if at each point you have an acceleration and an amplification, and then a diminution or a diminishment on this side, or a purposeful stagnation on this side, what happens over that amount of time? All right, so we made it to 1944. In 1948, we have Shelley versus Kramer. The Supreme Court ruled that while private racial covenants were not illegal, enforcing them in court was unconstitutional under the 14th Amendment. Remember, 14th Amendment guaranteed equal protection. The way segregation was able to function is this notion of separate but equal. So even though black people couldn't rent an apartment from Joe's company, because black people can rent an apartment from somebody, they just had to be black or Chinese, then we still have equal access to apartments. It doesn't take into consideration, well, are all the black and Chinese people forced to live near toxic dumps? It doesn't take into consideration if you have to be able to file certain paperwork, and that paperwork has to be done by a certain company within a certain municipality, and none of them are black owned, then that means the black folks never can get that paperwork done. How would you expect the land ownership to be equitable? But what was ruled is, like, under the 14th Amendment, we can't enforce them in the courts, but you can draw up a restrictive covenant. And if the two individuals that engage in it agree to it, then that's totally fine. It just, if it makes it all the way to court, we won't be able to enforce it. So as late as 1948, restrictive covenants were still being put to use. They just were no longer enforceable at a court level. In 1953, the Supreme Court ruled that courts could not award damages to individuals attempting to enforce racial covenants, further discouraging enforcement of the covenants. So up till 1953, if you had a restrictive covenant, even though it goes against the Constitution, if for some reason someone violated your covenant and you were supposed to be able to engage in punitive damages for violation of that covenant, you were able to do that. And in 1953, they're like, no, you can't punish people for actually obeying the constitutional law. All right. Then 1964, you have the Civil Rights Act. And specifically the Civil Rights Act of 1964, targeted discrimination in public accommodations, employment, and education. It was part of a broader movement to dismantle racial inequality, setting the stage for further fair housing legislation. So in conjunction with the Civil Rights Act of 1964 and the Fair Housing Act of 1968, which includes Title VIII of the Civil Rights Act of 1968, it prohibited discrimination in housing based on race, color, national origin, religion, sex, familial status, or disability, specifically outlawing racially restrictive covenants. So all the way until 1968, there were ways to implement restrictive covenants when it came to land ownership and prevent people of African descent from buying land, owning land, or retaining land in the United States. It is currently 2025. Theoretically, the earlier colonists landed 1620s. So between 1620 and 1968, black people were limited either in how they were awarded contracts, how those contracts were enforced, how the court supported them, how municipalities work, how private owners, how developers work. So from 1620 to 1968, there were all those limitations on access to land, land ownership when it came to black folks. So what would you expect in 2025? You think that now there's a culture war? You think that now America is in the worst place it's ever been in terms of identity politics? No. From 1620 to 1968, white folks were able to say black people can't live in this area, and black people had no recourse. That's wild. Okay? Let's keep it moving, though. 1968, we had Jones versus Mayer Co. The Supreme Court ruled that Civil Rights Act of 1866 prohibited racial discrimination in private real estate transactions, reinforcing the Fair Housing Act. So in 1968, they had to go all the way back to 1866 to show and prove precedent that you can't discriminate when it comes to housing. All right. So post 1968, you have the removal of restrictive covenants. Following 1968, restrictive covenants became illegal. Property owners began removing them from property records, with some states passing specific legislation to facilitate this process. Why? Because your deed is an add-on type of document. With certain documents in the United States, you file them. If there's something wrong, you replace it. It's like, oh, we did that wrong. Tear that one up. Here's a new one. Others, you redact and you take things off. Others, it's only add-on. And so that at every time in history, you see a new understanding of the document, but nothing gets removed from it. When it comes to restrictive covenants, a policy had to be put in place to allow governments, municipalities, or individuals to actually remove that language from the document. Because on the deed, the original deed, it says, cannot sell to a Negro, cannot sell to a Chinese. You can add on whatever, and the courts can say we won't enforce that covenant, but can you remove the covenant if part of the deed or part of that note or that document is that it never is altered? How do you alter that? And how do you make sure that it can't be enforced in the future? Now, a person would say, wait, this makes no sense. If we know that the Supreme Court has already made decisions, we know that Civil Rights Act in 1968 took place, then who cares if the language is still in the documents? There's nothing that anyone can do with it. Well, my friend, as you've seen with abortion and reproductive rights, if the federal government decides to say the states can figure this issue out, the federal government will no longer get involved in issues around race, gender, sexuality, marital status, whatever. The states decide that all for themselves. Well, at a state level, some of these policies are still on books. They were never taken off the books. They were never at a state level prohibited or banned. So if the federal government removes protections, then the states can go back to enforcing this language. So I'm a proponent of having the language removed, redacted, or in some way mitigated. So let's keep moving. We'll get into more recent acts. The Agricultural Improvement Act in 2018, known as the 2018 Farm Bill, it included provisions to assist black farmers who had faced discrimination in federal agricultural programs aiming to address the historic decline in black-owned farmland. And in 2021, you had the American Rescue Plan Act. Included debt relief for farmers of color to address historic discrimination. Legal challenges have delayed the full implementation. Right. So, of course, they still didn't do it. So in those 18 little steps, I try to give you a very quick and cursory, like perfunctory level introduction to land rights and how you look up now and notice that, A, the black people didn't really leave the South. Like when you look at a map and you do an overlap of the Confederate States and where black people lived in 1890, and then you look at a map of where we live and population densities now, we still live in Georgia, Florida, Alabama, Mississippi, Texas, Louisiana, North Carolina. We're not out in Maine. Why? There was no slavery up there, supposedly. Why didn't we move to Maine? We're not out in Washington State. We're not in Oregon. Why? Well, Oregon was, literally, Portland was a sundown city where you could work in Portland as a black person, but you couldn't live there when the state was first forming. Oregon at one point was a state for whites, And so when we think about America and why we are where we are, we should look at the history, look at the maps, look at the legal discussions. And it makes sense why you don't see black people in North Dakota, why you don't see black people in Montana, why you don't see black people in Idaho. We moved out there. There was a larger community per capita in Montana 100 years ago than now. Black people moved out there, and then white folks moved out there and ran off the black people that were there. And so we need to talk about it. We need to talk about how we seek restorative justice when it comes to these policies and these principles and what can be done. I don't want to just bring up the negative and not give any possible understanding of what can be done moving forward. And I bring this up also to ask this question of why do all the black people live around each other? Why is segregation so prevalent? And one could analyze socioeconomic and political factors that have been at play in the black community using the following examples. Well, black folks want to live amongst each other. I can see why you'd say that. Humans are naturally tribal and don't want to integrate. I could see why colonists would want you to believe that. Owning land requires a particular understanding and or education that has been historically difficult for black folks to attain. Is it difficult for black folks to attain it, or have white folks purposefully made that almost impossible? Again, we got to ask the questions a certain way. Black folks moved to cities following an industry and jobs, and it wouldn't make sense for them to buy rural land. Now, I want y'all to do a breakdown, like do a question to yourself. If black folks for 150 to 200 years have been working in an agricultural setting, had been brought over from Africa because they were scientists and doctors there, and knew botany, knew plant medicine, knew plant sciences, knew horticulture. So they weren't just all big brutes they also, the colonists stole doctors and intelligent brainiacs, came over and helped keep them alive over here. So you have folks who've been doing that for 200 years. They're granted some type of time period of expansion, and they're not under the thumb of enslavement. They all move up north and work in factories. That wouldn't make sense. Why wouldn't they buy land, move to land, or follow the Western expansion and engage in agricultural activities, which they are very skilled to do? Well, one of those reasons are racially restrictive covenants. And racial restrictive covenants are clauses in property deeds that prohibit people of certain races, colors, religions, or national origins from owning, leasing, or occupying a property. They were a common tool used in the early 20th century to prevent black people from accessing the housing market. I posit that one of the most influential mechanisms has been the restrictive racial covenant. Although they have not been enforceable since the Fair Housing Act was passed in 1968, the treatment of black folks as chattel property until emancipation, the anti-black property ownership practices that took place post-Civil War and Reconstruction, and the subsequent 50 years of restrictive covenants enforced by the federal and local governments have carved out a path that self-perpetuates. 49 out of 50 states implemented restrictive covenants against black folks. Hawaii was the only state that did not. By the time Hawaii was admitted into the U.S., covenants could no longer be established, but they were still enforceable. There's been no compensation, restitution, or restorative action offered to affected communities, only an acknowledgement of historical injustice. The first restrictive covenant to restrict the sale of property on the basis of race or ethnicity appeared in Brookline, Massachusetts in 1843, where deeds from the Linden Place subdivision included a clause stating that the residence could not be sold to any Negro or native of Ireland. You can check Magruder, 2015 on that. The pace of deed restriction accelerated rapidly through the 1910s and 1920s. A 1926 Supreme Court decision may have accelerated the spread of racial covenants throughout the country. In Corrigan v. Buckley, the Supreme Court declined to hear the case, allowing an earlier ruling against the defendant, Irene Corrigan, to stand. Corrigan had sought to sell her covenant property to an African-American woman. The court argued that while states could not engage in racial zoning, nothing prohibited private individuals from agreeing not to sell their homes to people of designated races, ethnicities, or nationalities. All right, so the courts enforced that. What we found is that not only did private citizens engage in the practice of restrictive covenant use, but entire towns, cities, and counties engaged in the implementation of racially restrictive covenants. So when I think of the roles of municipalities at federal, state, and local level, zoning and dealing with probate adjudication, inheritance, sundown towns enforced by political officials or law enforcement, state capitals, court systems, and legislative institutions that enforced or advocated for racially restrictive covenants. Like imagine you're part of the segregated South and you need to go into the courthouse in order to file property papers, and you know the people from the Klan work in the courthouse. The judge is in the Klan. All right, so then we think about lack of eligibility for programs in areas black folks were zoned to live in, so that their whole areas, not just redlining happened when it came to private residential housing, but there were economic freezes and moratoriums on loans in commercial areas that were predominantly frequented by black folks. So the municipality, as well as then the local banking institutions, basically chokeholded the growth of the black community by limiting the availability of funds. All right. So USDA, Homesteading Act, historic preservation is also involved in this process. We also look at the role of private industry when it comes to segregation and restrictive covenants and why we all end up living separately. You have redlining by the banks and the U.S. government working in conjunction. You have unfavorable or prohibitive loan rates and predatory loans, fewer loans given and loan refusal, collusion with other exploitative industries such as insurance and title companies, and moratoriums on loans in black areas. You also look at developers. Developers weren't building for black folks. Like literally, there were developers who were like, we will not build in areas where black people live. There are other developers that refuse to sell to black folks, whether it was real estate businesses or whether it was individuals. There were developers who said, we won't sell to black people. Then establishing unfavorable conditions for black folks. When you think about the developers that would sell, and you think about some of the historically well-known and discussed kind of quote-unquote slumlords, there was this understanding that if you owned a building or if you sold to black people, you didn't have to treat them properly, that they wouldn't be able to take you to court, and they wouldn't receive equal treatment in court. And then you think about the lobbying for restrictive zoning, that developers are able to push local governments in a direction when it comes to who can live where, how many of them, and in what way the city has been divided for use. I'm not getting into it, but city planning, whether it's Euclidean, whether it's not, there are a whole lot of discussions around that. But understand, if you're watching this, you can't do what you want just because you own a building. The city has been zoned in a lot of cities. And they will tell you, a place like DC or New York, they will say, this area cannot have warehouses. This area cannot have residential buildings. This area has to have mixed use and to this amount and number. And zoning and filing for zoning and lobbying is something that developers are able to manipulate. Then we also, when we think about restrictive covenants and why we're still segregated, we got to include the insurance companies with higher rates, not offering plans, predatory practices, title companies used as a tool to segregate and dispossess, private lenders use predatory practices, collusion, basically loan sharks, and trade groups. The United States Real Estate Associates of America, that association was the one that enforced restrictive covenants. It basically was like, do not work with people that will not implement these covenants. So the trade association, not the bank, not the seller, not the buyer, the trade association for real estate agents help push restrictive covenants in the United States. And we think of the role of private citizens, clearly the individuals that say, I won't sell to a black person. I won't sell to a Chinese person. The neighbors are a group of friends that get together, and there's nothing official, just as friends. It's like, yo, Mike, Bill, yo, when you sell your house, don't sell to a black person. Don't sell to a Chinese person. Then you have neighborhoods, housing association, or organized groups to where we're part of an HOA. It's not just on the low. It's not just a couple friends who decide, but to where our subdivision says, we're not doing that. And then you have the complexes, the subdivisions, and a tenants group where they don't decide, where when they buy into the property, it is given that the property developers in establishing the property have said, you cannot sell to black people, Chinese people, or whoever else. Then we're talking about entire municipal areas controlled by powerful families, where if you sell to, we will punish you in various ways. So let's say you have a white family that owns numerous buildings in downtown Raleigh, North Carolina. If one of the people within, someone buys one of their buildings, then sells to a black person, and they are attempting to grow their business as a developer or real estate magnate, and they go try to buy more buildings, the real magnate in the area will say, no, you bought from us and then sold to some black people, and we told you that's not allowed. We're never selling to you again. And they ostracize that person. So what people learn is, as white folks, don't help black people, or else other white folks will ostracize you. And in business and in money, it seems like people follow the path of least resistance. So all this led to black folks inhabiting limited space predetermined by non-community members in limited proximity to material resources, employment, education, healthcare, transportation, business opportunities, commercial activity, and freedom of mobility, as well as the frequency of disrepair, isolation, lower property rates, prohibition from relocation, and overall depreciation of home values and assessments. So the people in the isolated, segregated neighborhoods cannot move to other parts of the city, so the asset that they own cannot be leveraged unless they move out of town. How does this affect community and generational wealth? So that's your general discussion about modern segregation and how it ties into restrictive covenants in rural areas. All right? If you have any questions, hit me up. I'm going to post parts of this as we go on. And I'll be giving a discussion on the 16th with a little bit more depth, and you'll be able to see some of the maps that we've generated, and we'll get into a bit more of the statistics. All right? I hope all y'all are well. Check us out. Black Land Ownership is how you can find me, co-founded by me, Chris Carr, and Melissa Hunter-Gurney. And we like trying to talk about history, try to understand how we ended up where we are now, what we can do to rectify the situation. And one thing you can do is talk to your local municipality. Get the language removed from the deed. If you find out that your property had a restrictive covenant on it, you can get that removed. In most places, if you can't get it removed, you can get it redacted. All right? And the municipality will help you pay for it. All right, so holler at me if you have any questions. Peace.